He leaned forward across the defendant's table, and he said my wife's name, not loudly, not as a shout or a demand. He said it quietly, the way someone says something when they want you to understand that they've done their homework, that they know things, that the knowing itself is the message. He mentioned where she walks in the morning. He mentioned the park, and then he leaned back in his chair, looked at me with calm, steady eyes, and waited to see what I would do. In 38 years on this bench, no one has ever done that. I want to tell you what happened in the 10 seconds that followed, because those 10 seconds are the reason I'm telling you this story. Not what I did after, not the federal response, or the investigation, or the sentences. What happened in those 10 seconds inside me before I said a word. If you believe that justice must stand firm, even when standing firm is frightening, please subscribe before we go any further. This story is one I have never fully told before, and I want it told to people who understand why it matters. Now let me take you back to that October morning, and I want to be honest with you throughout, not dramatic, honest. My bailiff found me in chambers before the session began. His name is Officer Santos, and he has worked beside me for 11 years. He is a steady, experienced man. He does not rattle easily. That morning he knocked on my door and came in and closed it behind him. Your Honor, he said, I want to brief you on the first case. Marcus Rodriguez, 28 years old. His father runs what federal investigators believe is the largest drug distribution network in New England. The son has no prior convictions, which means his father's lawyers have been doing their job. But the arrest 3 weeks ago was significant. They found 500 grams of fentanyl in his vehicle. He paused. He goes by Tank. I just want you to know what you're walking into. I thanked him. I finished my coffee. I straightened my robe, and I walked out to my bench. I have learned over nearly 4 decades not to let a defendant's appearance tell me who they are. I have seen people who looked frightening turn out to be gentle. I have seen people who looked gentle turn out to be the most calculating individuals I've ever encountered. Appearance tells you very little, but presence tells you something. Marcus Rodriguez filled my courtroom the way weather fills a room. Not because of his size, though he was a large man, because of the certainty he carried, the absolute, settled certainty that this proceeding was something happening beneath him, and that he was attending it out of a kind of polite tolerance that he could withdraw at any time. He sat at the defendant's table the way a man sits at a restaurant. He's decided he'll probably leave before ordering. The clerk read the charges: possession of fentanyl with intent to distribute, a Class A felony. His attorney entered a not guilty plea immediately. Standard procedure. I looked at the defendant. Mr. Rodriguez, I said, I want to make sure you understand what you're charged with. 500 grams of fentanyl is not a recreational quantity. It represents a lethal threat to the community this court serves. Do you understand the seriousness of these charges? He looked at me, and what I saw in his eyes was not defiance, exactly. It was something more unsettling than defiance. It was pity, the kind of look a person gives someone they consider well-meaning, but fundamentally naive. Your Honor, he said, and his voice was measured, careful, almost respectful, in the way that makes you understand very quickly that the respect is performance. I think there may be some misunderstanding about the situation here. The situation, I said, is that you were found in possession of enough fentanyl to kill hundreds of people. That's not a misunderstanding. That's a fact documented in a police report, corroborated by laboratory analysis, and supported by body camera footage. What specifically do you believe has been misunderstood? He smiled, a small, patient smile. Judge Caprio, he said, not Your Honor, my name, specifically, deliberately. I've watched your show, Caught in Providence. I know your reputation. You're known for understanding that people deserve second chances, that circumstances matter, that compassion is part of justice. He paused. I'm hoping we can approach this situation with that kind of understanding. He was trying to use my own philosophy as leverage. use the things I had said publicly about mercy and humanity, turn them into a tool for avoiding accountability. It was, I will admit, a more sophisticated approach than I usually encounter. Mr. Rodriguez, I said, my compassion is not a negotiating position. It is a response to genuine remorse and honest accountability. I have reduced fines for a woman who lost her husband. I have shown mercy to a young man who made one terrible mistake and stood in front of me with tears on his face and told me the truth. In 38 years, I have tried to treat every person before this bench as a human being deserving of dignity. I looked at him steadily. What I have never done is mistake compassion for weakness. And what I'm seeing from you right now is not remorse. It is strategy. Something changed in his expression. The patience thinned. Your Honor, he said slowly, I just want to point out that justice works in both directions. You talk about the harm that drugs do to communities, but what about harm to families? What about people who think they're safe because they have certain protections? Officer Santos moved, not dramatically, just the small, precise shift of a trained officer whose instincts have been activated. Mr. Rodriguez, I said, are you threatening this court? He leaned back, opened his hands, palms up, a gesture of innocence. I'm not threatening anyone, Your Honor. I'm just making an observation about how things work. Providence is a small city. People know each other. Everyone knows where everyone lives. Your house on Elmwood, your wife's morning routine through Roger Williams Park. A pause, deliberate, unhurried. Your grandchildren's schools. It's a close community. Sometimes, when decisions get made that certain people don't appreciate, difficult things happen to people who thought they were protected. I want to tell you about those 10 seconds, because they are the part of this story that I think matters most. In those 10 seconds, I was not thinking about the law. I was not thinking about procedure or contempt statutes or federal jurisdiction. I was thinking about my wife. I was thinking about her walking through that park in the morning, the way she does, the way she has for years, the rhythm of it, the routine of it, the way she stops to watch the ducks on the pond, the way she calls me afterwards sometimes, just to talk. He knew that routine. He had described it to me, calmly, in a room full of witnesses, as a way of saying, I know how to reach her, and you know I know, and now you have a choice. That is what intimidation looks like at its most sophisticated, not a shout or a lunge, a quiet demonstration of knowledge, a reminder of vulnerability, a question asked without words. What are you willing to risk? In those 10 seconds, I felt something that I am not ashamed to name. I felt afraid, not the paralyzing kind, not the kind that shuts you down, but the real, honest, physical kind that comes when something you love is suddenly in the field of a threat. And then, in that same 10 seconds, I felt something clarify inside me, because I understood that this was the moment. Not a theoretical moment from a law school discussion about courage and justice. This actual moment, in this actual room, with this actual man looking at me and waiting for me to calculate whether protecting my family required softening my response to him. He had made a bet. He was betting that I would flinch. I stood up. Mr. Rodriguez, I said. My voice was level. I worked to keep it level, not because I wanted to perform calm, but because what I was about to say needed to be heard clearly, and panic serves no one. You have just, in open court, in front of witnesses, with a court reporter recording every word, described the daily routine of my wife and the location of my grandchildren's schools. You have framed this as a community observation. You have implied that decisions I make in this courtroom could lead to difficult things happening to people close to me. I came around from behind my bench. I want to be very clear about what just happened. That is a threat. It is a threat against a federal judicial officer, delivered in open court. It is documented on the record, and it is the most serious mistake you have made in your 28 years of life. His attorney was on his feet. whispering urgently, trying to create distance between his client and the words that were now permanent in the court record. Tank Rodriguez was not listening to his attorney. He was looking at me, and I believe, that he was genuinely surprised. He had delivered that threat to people before, in other rooms, in other circumstances, and those people had heard it the way he intended them to hear it, as a warning to stand down. He had not expected me to stand up. "Officer Santos," I said, "please contact the Federal Bureau of Investigation and request an immediate response to this courtroom." I looked at Tank Rodriguez steadily. "And please secure the defendant." Within 8 minutes, federal agents were in my courtroom. I will not over-dramatize what followed. The legal machinery that activates when a sitting judge is threatened in open court is significant, but it is not theatrical. It is paperwork. It is procedure. It is the system doing what it was built to do. What I will tell you about is a different moment. It happens while we were waiting for the agents to arrive. The courtroom had gone very still. Tank Rodriguez was seated, flanked by bailiffs, no longer leaning back with his arms spread. His attorney was at the table beside him, speaking very quietly. The gallery, which had been full that morning, was completely silent. And in that silence, Tank Rodriguez looked at me, not with anger, not with the cold calculation I had seen earlier, with something I can only describe as bewilderment. He had grown up in a world with specific rules, rules about power, about who had it, how it worked, what it could accomplish. His father's wealth had been a constant demonstration that those rules were real, that money could make problems disappear, that the right pressure applied to the right place produced the right result. He had watched it work his entire life. He did not understand what had happened. He did not understand why the threat had not worked. I looked back at him, and I felt, this is the honest truth, something that was not anger and was not satisfaction, something closer to sorrow, because what I was looking at was a 28-year-old man who had never, in his entire life, been given a reason to believe that there were things money couldn't move. And now he was learning it in the worst possible way. The agents arrived. The formal charges were filed. He was taken into federal custody. As he was let out, he turned and looked at me one final time. He didn't say anything, neither did I. The investigation that followed is a matter of public record. I am not going to give you numbers and raid counts as though this were a box score. What I will tell you is that the threat made in my courtroom that morning, the attempt to use my family as leverage, did not protect Marcus Rodriguez or anyone connected to him. It accelerated every consequence. What he meant as a warning became evidence. What he intended as pressure became the foundation of a federal case. The strategy of intimidation that had worked, presumably, in many other rooms, failed completely in a room where every word was recorded, where officers were present, and where the person being threatened was a judge who had spent 38 years understanding that justice, which flinches under pressure, is not justice at all. 6 months after that morning, I received a letter. It was forwarded through the federal prison system, handwritten, several pages. I read it twice before I put it down. Marcus Rodriguez wrote that he had spent the first few months in federal custody angry. Angry at me, at the system, at the circumstances. He wrote that he kept replaying the morning in my courtroom and asking himself where he had made the mistake, what he had miscalculated. And then he wrote he had stopped asking that question because the question assumed that the only error was tactical, that if he had said something different, applied pressure differently, calculated more carefully, the outcome would have been different. What I finally understood, he wrote, is that it wouldn't have been. Not in your courtroom, not with you. You weren't going to move. And the reason you weren't going to move isn't because you didn't hear me. It's because you heard me and chose not to. He wrote, I grew up watching my father make men afraid. I thought that was power. I thought fear was what moved the world. You showed me something I had never seen before. Someone who was afraid. I know you must have been afraid, and who did the right thing anyway. He wrote, I don't know if that changes anything for me. I'm going to be here a long time, but I think about it. I folded that letter and put it in my desk. I think about it too. People sometimes ask me, friends, colleagues, people I've known for years, whether that morning changed me, whether being threatened the way I was threatened, in that room, in that way, changed how I felt about the work. I always tell the truth. It changed something small, and it changed nothing important. What changed? I am more aware now of the weight of this work, of the fact that standing between powerful people and the consequences they want to avoid is not always comfortable, that there are people for whom the law is not an abstract concept, but a direct obstacle, and who are willing to try almost anything to move that obstacle. I was aware of that before. I am more aware of it now. What did not change? I walk out to that bench every morning. I read the cases. I listen. I try to be fair. I try to see the person in front of me clearly, not the crime first, not the record first, but the person. I do this because I believe it matters. I believed that before October. I believed it during those 10 seconds when I was deciding what to do. I believe it now. The law is not a perfect system. No institution built by human beings is perfect. Courts fail. Judges make mistakes. Justice is delayed and sometimes denied. But the aspiration, the commitment at the center of this work is real. It is worth protecting. It is worth the discomfort of protecting it, because the alternative is a world where the man with the most money and the most willingness to threaten gets to decide how things go. I have spent 38 years refusing to live in that world. I intend to spend whatever time remains on this bench doing the same. There is one more thing I want to tell you. A few weeks after the hearing, I came home one evening to find my wife in the kitchen. She had made dinner. We sat down together, the way we always do, and I told her what had happened that morning. I had not told her before. I had not wanted to worry her. She listened to the whole story. She didn't interrupt. When I finished, she was quiet for a moment. Then she said, "Were you scared?" "Yes," I said. She nodded. "Good." A pause. "It means you understood what was at stake." She got up and refilled her glass. "I'm still going to walk in the morning," she said. That is the woman I married. And that, if I am being honest, is where most of my courage actually comes from. Not from 38 years of judicial experience. Not from training or temperament or professional discipline. From watching a person I love choose not to be made afraid. If this story stayed with you today, share it with someone who needs to hear that courage is not the absence of fear. It is what you do while you're afraid. Share it with someone who is facing something difficult and needs a reminder that standing firm, even when standing firm costs you something, is the most important thing a person can do. It is. I have believed that for 38 years. I believe it still. Order in the court.